синхронний переклад на англійську мову. Синхронно, добре, щоб ви говорили повільно. Думаю, часу вистачить. Окей. Колеги, доброго ранку.
Dear colleagues, good morning. Ukrainian Crisis Media Center starts its working day, and the first topic of briefing is a procedure of opposing control of implementing the law on settlement of conflict of interest in the work of judges. Our speakers are Tetiana Chumachenko, head of the Committee on Ethics, Resolution of Conflict of Interest and Professional Development of Judges, and professional development of judges, and Virgilijus Valančius and Julia Zimlitska, expert of European Union on reforms in investment sphere, and Petro Pavlichenko, an expert of European Union project on justice reform, will also speak later. Good morning. The law about the justice systems goes that the Council of Judges is an organ, is a body which controls compliance by the judges with the provisions of conflict of interest. And the Council of Judges in February 2016 approved the regulations imposing control of implementing the law on settlement of conflict of interest in the work of judges. This regulation contains the norms how judges and judicial self-government bodies should work and should act if conflict of interest is expected or it is in place. More details will tell us the head of the Ethics Committee and Settlement of Conflict of Interest, but I would like to emphasize that this is the first provision regulating settlement of conflict of interest in any governmental institution, and the Council of Judges is pioneering in this area. Proceeding from this, we understand that these regulations will be finalized and may be corrected, and some conflicts of interest may be withdrawn from the provision, but this is a positive fact that this provision, this procedure has been passed. I hope the judges will treat these provisions with understanding, and this way we will try to put our joint efforts into renewing the confidence in courts. Good afternoon, dear colleagues. As my colleague said, this is the first pass when Ukrainian judges demonstrated a good example, I think, and the European Union's project on support of judicial system reform. Our experts and foreign experts of our project helped to develop these regulations. We have best practice from the European Union countries, and now we have been discussing with the judges in regions Kharkiv, Dnipropetrovsk, Lviv. Next week we will have discussions in Odessa how this will work in practices. It is very important in our opinion because the society has very high distrust, no confidence in governmental bodies and in courts. So the judicial community made a good step to demonstrate that judges and courts are ready to become open because declaration of private interest, this is transparency of judges and courts. That's good afternoon, dear colleagues. I am very glad and feel my responsibility, and even I celebrate today the approval of these documents by the Verkhovna Rada, because the Committee on Ethics at Verkhovna Rada cooperated with the projects headed by Mr. Virgilijus. What is the provision? This is the regulation on control over observance of legislation on the conflict of interest in the activities of judges. This procedure regulates the steps which a judge himself or herself may make to settle the conflict of interest, and what steps may take a council of judges to settle conflicts of interest, and which steps the council should take to ensure compliance. So there are 4 sections in the procedure. The procedure has been drafted on the basis also of the law on prevention of corruption, because the law on corruption prevention it defines which persons are subject to provisions on conflict of interest. You know that they are judges, MPs of Verkhovna Rada, Cabinet of Ministers. But I would like to emphasize that the judges were the pioneers. We have drafted the documents and they approved, and they are quite understandable for general public and give step by step procedure how a judge can act if he or she expects that there may be a potential conflict of interest, and what he or she should do when there is potential conflict, and what to do when he filed an application of potential conflict and he received the explanation that there is conflict of interest. What should then a judge do? We plan meetings with judges all over Ukraine, and we will also hold video conferences to explain this procedure, how to use it. I would like to attract your attention that the Committee on Ethics and Conflict of Interest is the organization to draft documents in conflict of interest area. So we need also regulations on our committee to be drafted. Because conflict of interest is many components, how it can be settled. That is why the work team also drafted the procedure, which has been also approved by the Verkhovna Rada, which defines all steps of the Council of Judges that are intended to accelerate settlement of conflicts of interest so that we can demonstrate outcomes of our works and they are useful for the society. This procedure includes many addendums. They concern various registers according to the law on judicial system. A judge should should submit a petition of expected conflict of interest, and the judge should file the statement about this. So to this end we drafted one addendum, and these statements, applications of judges, they will be registered, so there will be several registers established in order for the society to see transparency of the judicial system, because it is available but the society doesn't know about that. We proposed a voluntary declaration of private interests. There are no similar documents in Ukraine present. International Lithuanian experts proposed this tool because in Lithuania this tool has already been in place for a long time. This is also one of addendums to the procedure. A judge has the opportunity to file a voluntary declaration of private interest where he has some connections which can have any impact on his activities. Lithuanian judges, they are protected with this document. If a judge has filed such declaration, then he cannot be brought to liability for conflict of interest. And when if he has not submitted the declaration, then he is not protected. So far, we has not we didn't have such legislative framework before, and from now on we will be submit declarations and disclose our private interests as judges. We understand the core of this document, and I think that soon there will be some more proposals to the Verkhovna Rada so that this declarations are embodied in the laws. In order for you to easily understand what we should inform about and how it should look like, despite all applications and assessments should be written, we enclose several appendices to the procedure, to the regulations, where not blank forms are submitted, but the list of issues which you should include in your statement, in your petition, if you are a judge and you seek explanation from the Council of Judges. And in this document today, everything is available to start our activities, and the Council of Judges is ready for work. And during 2015, Council of Judges received many applications from judges seeking to explain whether there is a conflict of interest or there is no. And some judges filed petitions that they have conflict of interest, and we provided them replies, although there was no regulations which have now been approved already. So the first register we start, and we will put there the data about the petitions filed in 2015. We have already started this activity. The judges, in general, they are ready to any publicity in the context of settlement or prevention of conflict of interest. We should understand that judges are overloaded and they do not have enough time for meetings with public and to demonstrate their activities. But judges are ready, and we start our steps, and we understand the judges are interested, and judges demonstrate their interest to be transparent. Yulia Samlyska, experts of the EU project on support to the judicial reform. I would like to add that there is such saying that conflict of interest is a gate to corruption. Yes, prevention of conflict of interest is very important because such small situations when private interests start to have impact on public persons and the public persons then act for his own benefit, not for the benefit of society. This is the ethical challenge which push the person to corruption. These systems of declarations helps to find expected conflict of interest, and if it is already a conflict of interest, it could be settled, and and also it provides for bringing to liability of those judges who have already become corrupt due to the conflict of interest. In Ukrainian legislative framework, this is the first document. Nobody has issued any documents on settlement of conflict of interest in Ukraine before, and the powers of the Council of Judges, they concern out of court judge life. Other questions, they are regulated by legislations, and private interests settlement proposed by this document is a progressive tool which has been used not only in Lithuania, but in many other EU countries, and it is the first step to prevent and settle conflict of interest, and there is disclosure of information of public interest. It can't be settled if nobody knows about it. That is why these declarations has been introduced by this procedure in Lithuania. These declarations are included in the provisions of the law. We only start to move in this direction, and as we have no such legislation, that is why these declarations are provided as voluntary instrument, voluntary tool. But we also know that General Prosecutor's Office is thinking of adopting the same declarations for their staff. Almost all issues have been mentioned by my colleagues. I would like to say that previously positive approach was in prevention corruption area. In this case, we have managed to build dialogue with the judicial corps, and we have translated the European best practices in Ukraine. It is highly important for Ukraine. It is voluntary declaration of private interests, and this is the way for dialogue. We will move away from such approach when everything is legislated. I would like to add, as concerns settlement of conflict of interest in procedural way, this is which is out of the field of judges. any procedural code for today, as of today, and always, any code of procedure has several provisions regulating refusal to accept a nomination and challenges of judges. And such provisions, they also concern conflict of interest. There are no those two words, conflict of interest, in those provisions, but they are about it. This society should understand that judges were born in Ukraine, studied in Ukraine at school and universities, and moreover, they live in their houses, have neighbors, and go to some shops, banks. They are members of society, similar to other members of society. And it is nothing bad in that they know their teachers, their neighbors. For example, there are 1,000 students with whom this person can be acquainted with, but this is not a conflict of interest. Sometimes NGOs submit petitions saying that some judge hold a trial in the case of some person who was previously, who had met his classmate at school. But we do not think that this is a conflict of interest. Of course, abuses are possible by the parties. That is why refusal to accept a nomination and challenges of judges, they are working tool. And in small towns, if we use conflict of interest provision, like looking at who the judge knows personally, then in small towns judges can't work. So the case is the judges should have the right to try the cases where a judge even know persons. So the first steps have already been done, and I hope we will succeed. I'm sure we will succeed, because the judicial system have been reforming since 1992, and we understand that maybe sometimes we do not keep pace which is required, and sometimes the legislation is not observed. But the judicial community may demonstrate an example how can we settle conflicts of interest. As concerned voluntary declarations of conflict of interest, there is a very important aspect. There is no politicians, no lawmakers can demonstrate judges how to behave. Judges themselves, the council of judges, have proposed, have initiated this procedure on the part of the judicial community. Being a judge with 25 years of experience, I see that this is a very important way to approximation between the society and the judicial community. Thank you, Mr. Virgilijus. Now we start a session of questions. Yana Subko, Pravo TV channel. I have questions. How settlement of conflict of interest will be conducted, and whether Council of Judges can initiate the matter of dismissing the judge if the judge has not settled conflict of interest himself. And what about the potential conflict between the High Judicial Qualifications Commission and the Council of Judges? In the context whether it is possible, yes, it is possible. This is included in the procedure. You can see it on the website. The matter could be initiated at the High Qualifications Judicial Commission. We can't order, we can't instruct Commission what to do. I told you there were several petitions last year, several dozens of them about conflict of interest. There were both informations, communications, and there were also requests for explanations. If we think about the conflict of interest out of courts, this means that all persons which a judge is acquainted with, any person can blame a judge in the conflict of interest just because being acquainted with something, and we don't like such a ban on judicial profession. For example, for children of judges, that they can't be lawyers. This is not banned by the law if father or mother is a judge, but this is a human rights violation, you know. So the society and civil society should behave so not to violate human rights, but we will be thinking over and revising, and we will respond to all the challenges which we face today, where we should prevent something, not conflict of interest might not arise, but the main thing in the law on corruption prevention is to prevent. And settlement, this is just the final action, the final step. First, we should prevent any conflict of interest, and we focus attention on this. I would like to add that we have been working very actively with the Judicial Corps discussing this matter, and you now also local meetings of judges, you make them more empowered. When a person expects that a person can or might violate some provision on the conflict of interest, such a judge is afraid to disclose information, and the procedure in some stipulates that in some cases such a judge may apply to a general meeting of judges and then file a petition with public bodies. We also have another appendix enclosed to the procedure. There are several examples where a judge may expect conflict of interest, how the judge should think when he or she faces such situation, which circumstances may prove conflict of interest is in place. Thank you to all our panelists. See you again.